Ms. Khan, good morning.
Good morning. May it please the Court. My name is Donalyn Khan, and I represent the defendant appellant in this matter, the City of Newton. I guess I'm in the somewhat unique position to argue before you today the meaning of creation, amongst other things. The large, far-reaching issue in this case is whether municipalities can use Community Preservation Act monies for projects that contain elements of both creation and preservation, along with elements of rehabilitation. In this case, Your Honors, it was on a motion for summary judgment with an affidavit from an individual from the City of Newton Planning Department setting forth in specific detail the creation and preservation aspects of the two city park projects at issue. My brother had no opposing affidavits. The lower court disagreed with the city's argument on creation, which I will address here. And on the second issue of preservation, said, well, while there are elements of that I see in these affidavits, I think what you're really trying to do is rehabilitation, and therefore I'm going to find in favor of the plaintiffs. I submit on that issue, Your Honors, quite clearly what the court should have done is let that issue go before a jury or a judge determination of whether or not.
That issue, do you agree with the amicus position that one should use a predominant purpose?
Yeah, Your Honors, there needs to be some kind of test that is going to be used. And if we think about the possibilities of tests that we could use here, one, of course, would be for the lower court to be going through line items one by one and determining, yes, this looks like preservation, and number 20 does not look like preservation. I think that the test suggested by the amicus brief for the predominant purpose is a much easier test for a lower court to use in terms of what is really happening with this project. I submit that.
But aren't you really improving the land? You were making better access for disabled people. You were shoring up the sidewalks. You were doing things like that. Well, it isn't like sometimes when you take land, you have big problems, drainage problems or something like that has to be done to make the land usable. Well,
Your Honor, I submit in this case, the drainage issues were the big portion of both of the park projects in Stearns Park and Pellegrini. The parks have become relatively unusable in certain months out of the year because they are flooded out. The basketball courts are flooded out. The baseball and softball fields are flooded out. And significant monies of the over $700,000 that were proposed for these two projects were being used to address just that, drainage issues.
Much of the money was being used to address the drainage issues.
I would say to address drainage issues not only in piping, but also we had a rubberized surface, a play surface that was going to have a more porous drainage. Over half the monies in both of the projects were going to drainage issues.
And so you think it's just a matter of semantics whether you call that preservation or restoration?
Well, it's not really a matter of semantics. I mean, the definition of preservation is set forth in the statute.
And so is restoration, isn't it?
And so is restoration. Creation is the one that isn't. And on the preservation piece, the only piece that is quite specifically kept out is maintenance. That is not permitted. And I submit to you in looking at the affidavits, and you have quite clearly before you all of the elements of both of the proposed projects, that what was proposed here was not mere maintenance. And in terms of preservation, the definition talks about the preservation of the property from injury or harm due to, it could be natural elements like rain and flooding. This is the precise type of project that preservation was meant to address, being able to use these fields these playgrounds in Newton and to protect them from injury or harm, rather than every year having to, pump out and reseed and resurface because we have such severe drainage problems in both of these projects. So I think that on the preservation issue, quite squarely, we should have had more of a dialogue than simply the allowance of a motion for summary judgment. On the creation issue, which is...
Well, Sydney, what about the fact that that you've described this as improving the area, resurfacing, realignment, reconstruction, reorganization, upgrading, replacement? These are your words: restore, regrade, remove, restripe.
Right. Those were some of the words, Your Honor. With all due respect, those were some of the words describing the project. There are just as many words in there that talk about preserving and creating. I mean, these are words within a project that have a certain meaning to the average individual. We then have the words creation and preservation within a statute, which may have a different meaning. The fact that we've used words like reconstruct or improve shouldn't prevent us from making a preservation argument if looking at the project and most of the monies are precisely going towards preservation.
So you're not arguing that this park looks old, it's not used very much, could really use some new facilities, we're going to redo this park. That would not be included, correct? And that's not what this is?
That's not what this is. My brother will not agree with me, but I submit that's not what this is.
Isn't just a major facelift so that more people will use the park?
Absolutely not, and I would submit that over $700,000 would hopefully give you a lot more than simply a facelift.
I thought that when the Community Preservation Act was in the works, in the making, I thought it was designed and intended to create new green space and to take certain lands away from the potential reach of developers. Is there any legislative history on this act?
There is some legislative history, and as Your Honor says, there is history talking about the whole open space portion of it.
The amicus brief lays it all out with all of the, as far as I can tell, they've done a very thorough job laying out statute by, amendment by amendment and all of that.
It does, Your Honor, and it also goes into the fact that
There's as I understand, the original act said the acquisition, creation, and preservation of open space, correct?
of open space, and it goes on to say, and land for recreational
housing.
uses.
But what I'm saying is it's not, it can't be only to create new green space, because otherwise preservation and acquisition don't mean quite the same.
Correct.
Except that you can, if you acquire land, create a park, you can then preserve it and maintain it for future purposes with these monies as they continue to come in over the decades. But for purposes of preserving and maintaining a pre-existing park, that's off limits.
Well, I don't agree with that, and that's my creation argument. If you'd like me to address that, I'd be happy to. But, and Your Honor has just hit on, if we read this very carefully, there are two words there. And what I'm looking at is, I'm in 44B5 B2. It does say for the acquisition, creation, and preservation of land for recreational use. That is a permitted use. It goes on to say, though, that and for the rehabilitation or restoration of land for recreational use that is acquired or created as provided in this section.
Yeah.
So when you get to creation, there are, when you get to acquisition or creation, there are two words there. You can either, and acquire is conveniently defined for us. It's to buy or to get through a will somehow, to acquire the land. Under those circumstances, when you acquire the land, then you can also rehabilitate or restore. It seems...
Create a park.
Well, there's a separate word there, create, within the meaning of the statute. Now, this is where my brother and I disagree. What is the meaning of creation? Does create mean, and there are three possibilities. My brother would say that it means to create new land. to create new terra firma. I submit that that is not a reasonable interpretation under any conceivable application. And certainly, there's no new land going to be created in Newton in the foreseeable future as I can dream it. The second interpretation would be the creation of an area that had been previously used by the city for some other use, and now you're going to create a park.
But that's not this case. These are parks that previously existed.
Exactly. And I submit that what I've just described is one possible way to create land for recreational use. Another way to create land for recreational use would be to take a piece of land that cannot be used to its full potential for whatever reason. Here we've got flooding, we've got extremely old parks that are in such a state of disrepair that they simply can't be used anymore.
Yeah, but was that the expectation of the legislators?
I believe it was, Your Honor.
That's not these parks.
What's that?
That's not these parks either, is it?
Well, one of them I know fairly well, Your Honor, and it is these parks.
But they're not used at all because they're in such disrepair?
They are not used to the potential that they could be used with
But to create better parks.
Yeah.
I mean, you've got parks that are used for recreation. They've been previously created. They obviously need a lot of work. The question is whether this Community Preservation Act is intended to give you money to simply do what you should have been doing anyway, which is maintaining and upgrading these parks out of the normal operating budget of the city.
Right. Well, I would submit that, in terms of maintenance, that isn't the issue. If we keep that out of the parks have been maintained, and we do have a separate fund, a Parks and Recreation fund that does maintain the parks. The question is, did the legislature intend, when it created this statute, which I submit should be read broadly? They're all enabling pieces. There is nothing in this statute that talks about what you can't do except you can't do maintenance.
Isn't this in the nature of a tax?
It isn't in the nature of a tax. It's a funding that a city can opt into this statute. It is not a statute that everyone needs to follow. The city of Newton and about 127 other municipalities within the Commonwealth have opted into it. The tax, which is up to 3% surcharge on property taxes in the Commonwealth, is not at issue here. There is no argument that the tax is not proper. What is at issue?
Oh, but I'm saying you're using tax money for this purpose. You get a special surcharge.
Right, but it's the issue of tax is not what's at issue here. It's the funding source.
No, I understand, but when you talk about a tax, you have to strictly construe. It brings in other considerations. And this is a tax because there's a surcharge of not more than 3% of the real estate tax.
But
against
again,
real property, and then that money is subject to the recommendation of the CPA.
But again, Your Honor, it's not the fact of the tax is not at issue here. We all agree that it is okay to have this fund of money, and the fund has not been spent yet. It's still sitting. That $700,000 is still sitting in a fund for the determination of this court as to whether or not we can spend it for the projects that are before Your Honors. Or not. And I think all the other municipalities are sort of waiting with bated breath also, because we all have projects like this in our community preservation committee, going through the process right now as to whether or not they can be approved.
Back on the creation, I mean, since it's not defined, one may go to the dictionary. I mean, doesn't the sort of common meaning of creation not include having an existing park in which you're going to make more accessible to people with disabilities? I mean, it seems to me that is a stretching of the word beyond almost recognition.
Well, again, Your Honor, if we look to the statute itself and what could be the potential meaning of creation, and we go back into that second clause that I had talked about where you can rehabilitate or restore land for recreational purposes that is created within the meaning of this sentence. And then if I go back to the definition, which is set forth of rehabilitation, we have the remodeling, reconstruction, making of extraordinary repairs to, amongst other things, lands for recreational use. I mean, remodeling is remodeling. It's working on something that is already there.
Ms. Khan, can I just ask you one question? You said that there were many communities waiting with bated breath, and the amicus suggests that whatever our ruling is, that we apply it prospectively, and I assume that part of that is because there are projects that are underway that are similar to where the money has already been spent. Am I correct? That
is correct, Your Honor. There are projects that are out there where the money has already been spent. I mean, it may be a question of whether a 10 taxpayer suit would be appropriate in those places, in those particular cases. But I think there is a fear out there of projects that are already in progress that they not have to, especially in these financial times, refund money back into the CPC coffers if something was found to be improper.
Thank you.
Thank you, Your Honors.
Mr. Murphy-Andrewski.
Thank you, Chief Justice Marshall. Good morning. May it please the Court, my name is Guy Murphy-Andrewski. I represent the plaintiff appellees in this case. And I'm glad that my sister went first and provided a thumb sketch of truly the kind of conflicting concepts that are before you. But to sort them out, you may not require to engage in some kind of a Herculean effort to change the nature of the statute or to amend it by your decision. Going to the case of Zuckerman v. Hadley, which is actually cited on page 5 of the amicus brief. This court kind of indicated that for the purposes of preserving Hadley's bucolic character, natural resources, among other things, that it could participate in some state-enacted program that would, and I quote, as a practical matter, limit growth by physically limiting the amount of land available for development. And one such program that the court indicated was a Community Preservation Act, which, as the court stated, and I quote, allows communities to establish preservation funds that they may use for open space protection. And land for recreational use definitionally under Section 2 of the CPA, of the Community Preservation Act, is a subset of open space.
Because your sister is saying that that's exactly what they're doing. They're trying to protect some open space that happens to be owned by the city of Newton. But and they're trying to develop, the certain recreational aspects.
The development of the recreational aspects of a land that the city had already owned prior to CPA, neither acquired or created with CPA money, could not be improved along the lines that they have decided to improve it, as set forth in pages 2 through 9 of the plaintiff's submission to the court, both in scope, purpose, list of improvements, and so forth, because those lands had already been land for recreational use as they existed. Now, the problem is that when you're trying to protect or preserve open space, you're trying to protect it from something. And this court's own understanding of the CPA is that you're trying to protect it from development. And the pre-enactment legislative history of the Act also speaks to this. And we have submitted a few documents in the appendix to the submission we've made to the court, which comes from the initial drafts of the CPA when it was first considered. And one of the worries of the legislatures in terms of a finding was that they really wanted to stave off the loss of open space to development and sprawl and so forth.
Certainly,
and
it's certainly one of the clear purposes. The question is it the only clear purpose? And I think one of the things that this case presents rather significantly is that there are not, in many of the cities and urban towns, there isn't a lot of open space to be acquired. And the question is, did the legislature have an express intent to say we're not talking about those cities and towns, we're only talking about rural areas where there is the likelihood of acquiring new green space?
Well, that certainly may be true. But if a city were to acquire let's say, a derelict parking lot from an owner and turned it into green space or open space or land for recreational
Of course,
use.
there are some circumstances, but in many of the cities, there's very, very little open space left. It's possible that there could be a parking lot. It's also very likely that in areas where there's a parking lot and in a very built-up area, the city would not be in a position to acquire because the land is so expensive.
That's quite so. However, the legislation itself basically sets this firewall where one keeps rehabilitation of land for recreational use to land that is acquired or created with CPA money.
So,
And you're saying only newly acquired land can be, that money can be used only for newly acquired land and not for existing parks?
That's correct.
of course, if they're trying to protect open space, the open space that they're trying to protect could also be owned by the city. You know, if it's a part of a park that has fallen into disuse or lack of use, it could, and it's land that could conceivably be taken out of park usage and used, you know, for the construction of a public works garage. So the city is trying to protect this land and keep it in open use. Why can't that be consistent with the goal of the statute?
Because improvements that go to extending the use or the life or the useful life or the function of land that has neither been created or acquired with CPA funds is in the province of rehabilitation as the statute defines it. And it is perhaps unfortunate for the city, but there is this firewall. And to get over it by putting an elephant of a project, which is in millions of dollars, on the back of a fly and then try to have it soar over this wall and land in some field of legitimacy, it's really turning the entire statutory scheme of Community Preservation Act on its head.
Mr. Murphy-Vendeleski, could you help me? In your view, what is the difference between, if your position is that it has to be, as I understand, only newly acquired land, do you see any difference between newly acquired land, between acquisition and creation?
Yes, acquisition would subsume that there is a land already in play and that the city purchases it. Creation of land for recreational use, on the other hand, supposes that there is land and yet now the city steps in and buys it and turns it for its own purposes that is allowed under the Community Preservation Act to turn it into.
You lost me there. The acquisition, the city goes out and acquires the land?
Correct. Let's say the city...
Yeah, so it buys up. There's some open space. Farmer Jones submits a plan to subdivide his property into 10 buildable lots because he wants to sell them a single. And the city says, I want money to acquire that, correct? What is the difference between that and creation?
Your Honor, creation is not defined in the Act. So therefore, we have to go back to what the dictionary definition of it would, which is what presumably the legislatures may have had in mind.
So I'm asking you for
bringing about for the first time.
I'm asking you for your definition of creation.
Is to bring something forth for the first time. For example, if we had a pond and we were to drain it and then fill it and put a land for recreational use in the form of a soccer field on top of it, we have created land for recreational use.
Sounds like, without being flippant, it sounds like you've got a pond. It's water drainage flooding the, I mean, it's not a pond, but essentially what the city is saying, we've got these flooding, and what we want to do is to create a recreational area that won't flood. What's the difference?
Referring to the flooding of these fields that my sister referred to?
Right.
Well, that goes to the condition, the physical condition of these parks, which are pre-CPA. Therefore, in order to address that, we have to go under the rehabilitation definition of the Act. We can't go into the preservation.
But your point is that the rehabilitation aspect doesn't cover this, right?
The rehabilitation would cover it, provided that these parks were acquired with CPA money.
Yes,
or created.
that's the whole point, that these parks were not, quote, created or acquired with CPA money, right?
They were not.
Neither one.
Neither.
Yeah.
Does it have to be a park?
No,
Could the city buy the land and make a municipal golf course?
Or you could make a municipal golf course. It's land for recreational use, and recreational use is defined in very general terms by the statute as anything like trails, gardens, park, fields, ballparks, and whatnot. It excludes structures like
Should this-
stadiums
if we
and
agree with
racetracks
you,
and stuff.
if we agree with you, should this be prospective?
If you agree, Your Honor, those things that are already in the pipeline and are being basically kept at, at bay may not then proceed, which...
What about other things, if some money's been spent on them?
Well, Your Honor, that's a very, very interesting question, and you may have to grapple with that, because there is...
Doesn't Section 53, Chapter 40, Section 53 deal with that? 10 taxable inhabitants are entitled to relief and equity if a town or its agents are about to raise or expend money or incur obligations.
Because of that language that basically says come and come quick, if the money gets spent and projects get bulldozed through very quickly before the plaintiffs even have a chance to even come and ask for a preliminary injunction, then there is an issue as to whether the remedy is available or whether there is proper standing, whether this is moot. But fortunately, in this case, given these set of facts, the city of Newton had the magnanimity and the respect for the tribunal to actually put a freeze on the money and not proceed.
Of course,
Had they proceeded, it would be a different
suppose
issue.
the answer to the prospective question, if you win, is we don't have to deal with it here.
Well,
Wait for another case.
if that may very well be the case. However, if you draw a bright line, as we are requesting, that you keep mutually exclusive concepts of preservation and the concept of rehabilitation in these kind of cases, the signal will be very strong to the municipalities, and then the taxpayers may have an even chance, a level playing field to be able to come to court and at least show some reasonable prospect of success on the merits in case they want to come under that particular provision of the law for preliminary.
If we agree with you, that doesn't mean that the city can't maintain or preserve or do whatever it wants with these parks. They can do it, but just not with these funds.
That's correct. Just as one of the justices mentioned, there would have been something coming out of the operating budget or the capital improvement budget, but not this pot of gold. This is not for that purpose.
But as a practical matter, I mean, this idea of mutually exclusive firewalls doesn't really work, does it? I mean, a lot of these things have multiple, you can fit them into different categories of the definitions. So, I mean, how do you implement that as a practical matter?
You implement it, Your Honor, by not having or adopting what the amicus brief is suggesting, which is one of these tests that amalgamates everything and then says this is the predominant factor, therefore we're going to characterize the whole project based on that so-called predominant factor. The fact of the matter is, on the record here, that the drainage is not really a predominant factor of what the city of Newton wants to do these two parks, and the record appendix is very clear as to that.
Mr. Mefendeleski, I understand your position of the original acquiring, okay? But I want to go back to your creation definition. You said to me, if the city has a pond, right, and it wants to drain the pond to create some recreational use, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 taxpayers come in and say, you know, every now and then, once a year, once every 5 years, I go in and I, you know, just look at the water.
Yeah.
I find that recreational.
Yes, there is a provision for passive recreation.
I understand. So I'm troubled by the example that said that the 10 taxpayers that then come in and to say, you can't create a green space here because you didn't acquire, the city had this property, and now you're trying to change the use, you know, do something else with it, and that isn't proper under this act. You can do that, but you've got to get it from someplace else.
Well, certainly that pond wouldn't be land for recreational use, because every aspect of land for recreational use in the statute is somehow based on terra firma.
The perfect
Land for
example
this,
is
land for that.
the Esplanade. That was filled in land. It was swamp water.
Right.
Now it's a lake was created. That
Right.
was land that was actually created, and many of our coastal communities historically have created land for development and recreational use and a lot of other things by filling in harbors, lowlands, other things.
And they're making land off of the coast of South Korea, and they're making land on Greek
Oh, I understand
rooftops.
that, but what I'm saying is I'm trying to figure out where your point is at which the court looks, because if in fact there has been some recreational use of this pond, right, some recreational use, people have just looked at it, they haven't been able to swim in it, they haven't been able to, just take that, they haven't been able to swim in it, they haven't allowed boating there because they're worried about people filling in, and so what they want to do now is to create a swimmable, boatable water space, open space. Otherwise, it is just, this is in a city that has very little recreational open space.
Well-
Wouldn't your position be that you can't do that because you already own the land, it's already recreational, and you're just trying to change the purpose of it?
That goes to my sister's argument, in all fairness, that it's creation of new use for this area that happened to have been pond and now is going to become a field.
And you would say you can't do that.
I'm saying the question of whether we can pay CPA money for it may be questionable,
But I would
because
just-
it
that
is
was
still
your
because it's still a recreational.
Right. That was the example you gave to me, or you gave the court. You said, for example,
Well, the example I gave, I should have predicated on the fact that this was a pond that is owned in the private sector, and now the city grabs it and they said, I want to create land for recreational use here. But the one that is already pre-owned is precluded from being improved pursuant to what we have here in the statute at the moment.
so you are really saying it's only when a city or town acquires for the first time.
See, my time is up.
You may answer.
Yes,
that.
yes.
You must acquire for the first time. So this is property that has not hitherto been in the possession of the city or town.
Correct.
And can these funds be used to acquire land that is in the middle of a city that has no green space, an abandoned supermarket, a former supermarket parking lot? Can it be used to acquire that kind of blighted land?
Yes. In fact, it may have been one of the purposes of the statute, to stave off sprawl, to reverse the process, allow towns to build inventory of open space.
But it couldn't be used to take a Newton school that's falling down, raise it, and make a park there.
If it's a private school,
Oh, no, a
Newton
public school in Newton.
oh, no, then we have to talk to the school committee.
Thank you, Mr. McNally. We'll take a short break.
Thank you very much.
All rise.